Okay, let's unpack this. You know, if you're a savvy business person, you probably think a signed contract means, well, you've got a legally binding deal. Simple, right?
Seems like it should be.
But sometimes what looks like a solid, exclusive, long-term commitment can just unravel.
Uh-huh.
Because it turns out one party was never actually bound in the first place.
That's the hidden danger.
So today we are diving deep into that crucial requirement of consideration, and specifically this necessary ingredient that often trips up agreements, the whole concept of mutuality of obligation.
It really is the ultimate legal trapdoor, isn't it? We're going to give you a rigorous analysis, really break down what makes a promise illusory.
Illusory, meaning it sounds serious, but it's legally empty.
Exactly.
Yeah.
So, to do this, we'll first nail down the fundamental rule of mutuality.
Okay.
Then we'll apply a really structured analysis, FIAC, for those keeping score, to that famous 1924 case, Miami Coca-Cola Bottling Co. v. Orange Crush Co.
Ah, the classic.
Right. And then we'll pull it all together into a framework, like a checklist, that you can use immediately to spot these kinds of issues in any document you might sign.
Sounds good. So when we talk about contract law, we often hear this phrase, a promise for a promise. It implies this exchange, right? Both sides have to be obligated.
That's the core idea of consideration in bilateral contracts, yes.
But what happens if the promise on one side is, well, kind of flimsy? Like, the party can just choose not to perform, and there's no real penalty.
Yeah, that's where it gets problematic.
How exactly does the law define that point of failure, this requirement of mutuality?
So mutuality of obligation is absolutely essential when your consideration is based on these reciprocal promises.
Okay.
The general rule is pretty clear. Both parties have to incur some kind of legal detriment or obligation, something real they're giving up or taking on.
Makes sense.
Now, if Party A's performance is entirely optional, maybe based on their whim, or if they can just terminate the contract at any time without any restriction.
Like, just walk away.
Exactly. Then their promise is considered illusory. It imposes no real burden, no legal detriment.
And if one promise is illusory?
Then the contract lacks consideration. And generally speaking, it's unenforceable.
Okay, that makes sense for, say, a promise to get paid. But what about the whole contract? If I sign, let's say, a 5-year exclusive deal, and you performed your side for 2 of those years, does the entire contract just become void retroactively because my promise was flawed from the start?
Ah, that's a really critical distinction, and it's something courts grapple with constantly.
Okay.
The illusory promise, it means the contract lacks consideration so far as it remains executory.
Wait, executory? Hang on. For the listener, why is that term so important right here?
Right, good question. Executory basically means going forward or yet to be performed.
Stuff that hasn't happened yet.
Precisely. So the courts generally recognize that if the parties did perform the contract for a while, say those 2 years you mentioned, they might still be liable, maybe for damages, during that period where performance actually happened. You know, where goods were exchanged, services rendered.
Okay, so the past performance isn't just wiped away.
Not necessarily.
Yeah.
But the lack of mutuality means the contract usually cannot be enforced by the courts for its future terms, the executory part.
I see.
So the party who wants to enforce those future obligations, well, they have no legal basis to compel the other side to perform because that binding obligation, it never truly existed from the start.
Right, because the initial promise wasn't really binding on them.
Exactly.
Okay, here's where it gets really interesting then, because this is pretty much exactly the scenario that played out in Miami Coca-Cola over a, potentially very lucrative exclusive deal.
It really is a landmark ruling for precisely that reason.
Let's dive into the details of that case because I think it just crystallizes this whole concept perfectly.
Absolutely. It showed just how easily these seemingly ironclad agreements could be, well, defeated by a single clause.
Okay, let's analyze Miami Coca-Cola Bottling Co. v. Orange Crush Co. using that structured approach. First, what were the legally dispositive facts?
All right. The key facts are these. Orange Crush Company, they were the appellee, granted Miami Coca-Cola Bottling, the appellant, an exclusive license.
Exclusive.
And perpetual. It was a forever deal, theoretically, to manufacture, bottle, and distribute the soft drink Orange Crush within a specific territory using the Orange Crush trademark.
Okay, sounds like a big commitment from Orange Crush. What did they promise?
Orange Crush committed to supplying the necessary concentrate at set prices.
Yeah.
And, importantly, they also agreed to conduct advertising to support the product.
And Miami Coca-Cola said?
Miami Coca-Cola promised several things: to buy specified minimum quantity of concentrate, to maintain a proper bottling plant, solicit orders actively, and generally promote sales to increase the volume. Standard stuff for a bottler.
Oh, okay. Seems balanced so far. Where's the catch?
The catch, the absolutely crucial, fatal fact, was a specific clause, a proviso, buried in the contract. It stated that the appellant, Miami Coca-Cola, might at any time cancel the contract.
I might cancel at any time. No conditions mentioned.
None mentioned in the court's focus on this point. Just
Wow.
at any time.
Wow. Okay. So given that clause, what was the core legal issue the court had to decide?
The central issue was this: whether a contract that grants perpetual rights and imposes clear obligations on one party, Orange Crush, but also explicitly allows the other party, Miami Coca-Cola, to terminate the whole agreement at will,
Yeah.
is that contract rendered void and unenforceable because it lacks mutuality of obligation.
Right.
And consequently, could Miami Coca-Cola get an injunction to stop Orange Crush from canceling the deal later on?
Right. Could they force Orange Crush to stick to the deal when they themselves could leave any time? What rule did the court apply to resolve that issue?
The court applied a pretty well-established rule of contract law. Basically, when a contract's consideration relies on an exchange of promises.
The promise for a promise scenario.
Exactly. If one party reserves the completely unrestricted right to terminate the agreement whenever they please, that contract is unenforceable.
Why? What's the reasoning?
Because the non-terminating party's obligation, in this case, Orange Crush's promise to grant exclusivity and supply concentrate, it isn't supported by valid consideration from the party who can just walk away without consequence.
Because the walker isn't really promising anything binding.
Precisely. Their promise is illusory. The court explicitly grounded this in the great weight of authority, citing other cases that had established this specific principle about at-will termination clauses, rendering promises illusory.
But hang on, doesn't that feel, I don't know, incredibly unfair to Orange Crush? I mean, they committed to this exclusive, potentially perpetual relationship. They were locking out other potential bottlers in that territory.
Yeah, it does seem harsh on the surface.
Surely that big obligation on their side must have counted for something, right? Even if Miami could theoretically quit. How did the court's analysis handle the fact that Orange Crush was clearly giving up valuable rights?
And that really gets to the crux of the mutual obligation analysis. The court didn't ignore Orange Crush's burden. It even conceded that Orange Crush had obligations, absolutely.
Okay.
And it acknowledged that the bottling company, Miami Coca-Cola, might even have been entitled to damages for the period where they did perform under the contract
Right.
before the dispute blew up.
Right. For the time things were actually working.
Yes. But the key moment was when Orange Crush eventually tried to cancel the agreement themselves, and Miami Coca-Cola sued to stop them. Miami wanted to enforce the future, the executory performance of the contract.
They wanted the court to force Orange Crush to keep supplying them forever.
Essentially, yes. And the court's analysis zeroed in entirely on the nature of the appellant's promise, Miami Coca-Cola's promise, their promise to buy concentrate, to promote the product, all of that.
Yeah.
It was completely nullified, legally speaking, by their reserved power to cancel the whole thing at any moment without any penalty, without any condition, without restriction.
So, because Miami Coca-Cola hadn't really suffered any legal detriment, they hadn't actually given up anything concrete, not even the right to just change their mind later. Their promise was just an empty shell.
That's precisely it, an empty shell. Orange Crush was bound, at least until they tried to cancel, to supply and maintain exclusivity. But Miami Coca-Cola, they weren't truly bound to buy or promote beyond the very moment they decided they didn't want to anymore.
Wow.
So since the bottling company's promises were entirely illusory in the eyes of the law, Orange Crush received no genuine, binding legal obligation in return for its promises of supply and exclusivity.
So the exchange wasn't balanced?
Legally, no.
Mm.
The required mutuality of obligation was missing, specifically regarding the future enforcement of the contract.
Okay. And the final conclusion from the court?
The Circuit Court of Appeals affirmed the lower court's decree. They ruled the contract was indeed void for lack of mutuality, meaning Miami Coca-Cola lost. They couldn't get the injunction to stop Orange Crush from canceling, and they couldn't compare specific performance, couldn't force Orange Crush to keep performing for the future, the executory portion of the agreement.
So that perpetual license just, poof, evaporated.
Evaporated is a good word for it. The power to cancel at will killed the future enforceability.
Okay, to really make sure this distinction between a a real binding obligation and one that's just illusory sticks with you. Let's revisit our visceral thought experiment.
Ah, yes, the eels.
The eels. Imagine that world-renowned chef, the one known for bizarre techniques. He contracts with the supplier for 100 pounds of his absolute favorite ingredient, freshly harvested swamp eels.
Right, got it.
The supplier agrees to the term, goes out, does the work, harvests the eels. But the chef sneakily added a clause to the contract. It reads, "I promise to pay $5,000 for these eels." Sounds good so far.
Okay.
Unless I wake up on the delivery day and just feel like having chicken instead, in which case I owe nothing.
Sigh slightly. Oh, dear.
So what does that totally unrestricted escape clause mean for the poor supplier who's already got 100 pounds of eels ready to go?
Well, what's fascinating, or maybe infuriating here, is that the supplier is obligated. They have to harvest, deliver, hold the eels as per the agreement. They've definitely incurred a legal detriment, their labor, their costs, their time.
They're bound.
They're bound. But the chef's promise to pay, it's conditioned entirely on his internal, totally unrestricted, completely arbitrary mood. Feeling like chicken isn't a legal condition, it's just whim.
He hasn't given up the right to choose chicken. He faces zero penalty for exercising that whim.
None whatsoever.
So the supplier is basically trapped with the eels, but the chef is totally free. How would a court view that chef's promise to pay?
It's unequivocally illusory, no question. The supplier cannot enforce that contract against the chef to make him pay the $5,000.
Why not? The supplier did the work.
Because the chef's obligation to pay is simply non-existent until the very moment he might choose to perform by accepting the eels. Critically, this holds true no matter how much effort the supplier put into harvesting those eels.
So the supplier's effort doesn't save the contract.
No. Just like in Miami Coca-Cola, the court isn't focused on the effort expended by the party who is bound. It cares only about the binding nature of the promises exchanged at the time of the agreement. You need that mutual obligation, that two-way street of legal detriment, right at the outset for the contract to be enforceable going forward.
Wow. That analogy makes the whole concept of an unrestricted unilateral escape clause painfully clear. That one little phrase, "unless I feel like chicken," it single-handedly kills the enforceability of the entire future agreement.
It does. And that's why, if we connect this back to the bigger picture, if you are analyzing a contract, maybe negotiating one, especially anything involving long-term or exclusive rights, you absolutely need a diagnostic checklist. You need tools to spot these potentially fatal issues before they blow up into costly litigation or a deal falling apart. In this case, Miami Coca-Cola, it gives us exactly that framework.
Okay, so let's synthesize this. What's the checklist?
All right, first step, identify the promises.
Yeah.
You have to clearly articulate the specific exchange of obligations. Who is promising to do what for whom? Get it down on paper.
Makes sense. Like Orange Crush supplies concentrate and advertising. Miami Coke buys and promotes.
Exactly. Step 2. Check for an unrestricted escape clause. This is the critical one. Does one party, or maybe even both, have the power to cancel or withdraw from the agreement unilaterally?
And unrestricted is key here.
Absolutely key. Is it without any condition, without needing to give notice, without facing any kind of penalty or consequence? You're looking for red flag words like at will, at their sole discretion, maybe whenever they feel like it, like our chefs.
Got it. What's step 3?
Step 3. Determine the mutuality. If Party A's promise is conditioned entirely on its own unrestricted choice to either perform or terminate, meaning they haven't actually given up any legal right or freedom of action.
They haven't suffered a legal detriment.
Right. Then Party A's promise is illusory. It provides no real consideration for Party B's promise.
Okay. And the final step.
Step 4. Conclude on enforceability. If the consideration for the entire contract rests solely on that one illusory promise, then the contract is generally void for lack of mutuality. Especially, and this is crucial, regarding any future executory performance. Always focus on, does a party have to give up something, even if it's just freedom of choice for a period, or do they merely reserve the option to maybe give up something later if they feel like it?
That's a really clear framework. So that was quite a rigorous look at how just one seemingly small, maybe even innocuous-looking clause, that power to cancel at will, can completely unravel what looks like a perpetual license.
Yeah, it turned years of potential business into just an unenforceable intention, really.
It really proves that a contract isn't just about, making a promise in writing. It's about accepting a true, binding, and legally restricted obligation in return for the other side doing the same.
Absolutely. And, this raises an important final question, something for you, the listener, to think about. What if that Orange Crush contract had required Miami Coca-Cola to give, say, 60 days written notice before they could cancel.
Just adding a notice period.
Right. Would that small addition, that 60 days where they were still bound, that small period of required commitment, that potential legal detriment, would that have been enough to satisfy the mutuality requirement and actually save the agreement from being declared void?
Interesting. So even a small restriction might make the promise real.
It's definitely something worth mulling over, or maybe exploring on your own.